One of the things that we're looking at in the aftermath of the Elliott case in Georgia is how it is that it will affect other parts of the DUI case. Um, so there's a case, Mitchell versus State. I actually handled it in 2017, where we litigated whether or not the state could admit a person's refusal to submit to field sobriety tests in the case against them. I challenge the admissibility of the refusal to submit to fields on Fourth Amendment grounds. There's a lot of cases in Georgia that say that you cannot comment upon a person's refusal to submit to a search pursuant to the Fourth Amendment. So a person has a constitutional right to withhold consent to a search in any given case, and that the state can't turn around and use that against them at trial. That's sort of a basic principle of Georgia evidentiary rules. That's just the way that our law has developed. I challenged whether or not field sobrieties were in fact a search, and then whether or not you could use a person's refusal to submit to that search against them. The court went through this whole lengthy discussion and found ultimately that refusal of field sobrieties, that field sobrieties were not in fact a search, and therefore you could comment on that pursuant to the Fourth Amendment. It was not a constitutional violation for you to comment on that refusal to submit to field sobrieties. I did not challenge them on the self-incrimination grounds in the Georgia Constitution. That would have been the appropriate grounds to challenge them on. Aldrich versus State directly addressed this in a case that dealt with a defendant pre-arrest being required to drive his truck, perform an act of driving his truck upon scales. And if I had challenged that under Aldrich, and subsequently based upon Elliott, what we would have found is that I probably would have gotten a different result out of that part of the Mitchell case. So whenever you have a client who refuses to submit to field sobriety tests, make sure that you're challenging that on self-incrimination grounds under the Georgia Constitution, paragraph 16. If you're raising that challenge, then you're almost certainly going to have a result where the judge says, no, state, you cannot use a person's refusal to submit to field sobrieties pursuant to the self-incrimination provision of the Georgia Constitution, which protects you against both acts and statements. So that's the grounds that you really need to challenge the admissibility of that evidence. It's also really important that you recognize that this challenge, based upon compelled acts you cannot be required to perform or compelled to perform acts that may be incriminating against you, does not require a person to be in custody. So many people have a misunderstanding of paragraph 16 and whether or not it applies to both pre-arrest and post-arrest acts. And the answer is absolutely it applies to pre-arrest acts as well. So it does not require in any way, shape, or form that you be under arrest in order for that protection to allow for you to rely upon that. So don't be concerned about that at all if that's what your issue is. If you have any questions or you have any thoughts about how Elliott could be further expanded to protect us against other pieces of evidence that the state may be using or trying to use against us in DUI cases, feel free to comment below, drop me a line, or give me a call. My name is Ben Sessions. My phone number is 470-225-7710. Again, 470-225-7710. Thank you.